Notice of this meeting has been posted online for at least 72 hours. Members of the Commercial Board of Adjustment may be attending virtually in compliance with the Texas Open Meetings Act, although everyone is present in person today. The staff present today are Michelle Pena, Karen Moreno, Beth Knight, Daniel Guerrero, Nico Arias, Chris Austria, Justin Newhart, Ana Alvarez, and Estefania Barato. Chair, will you please call the meeting to order?
Yes. This is a special hearing for the Board of Adjustment considering an appeal from the Urban Design Commission. Today is the 6th day of March 2024, and I welcome everyone to the Board for Commercial Adjustments. This board is a citizen board appointed by City Council. By state law, a minimum of 9 members or alternates must be present to provide a quorum in order to conduct business. Today we have quorum with 11 members present. Today's meeting agenda can be found online at www.fortworthtexas.gov. Speaker registration forms for cases on today's agenda should have been turned in prior to the start of this session. Today's public hearing is being documented by cable television and video conference recording, which will be available on the city's website. To ensure a timely and orderly meeting, the Board of Adjustment requests that the following rules of procedure be respected. When not speaking, all online applicants will be muted in order to avoid any potential background noise which may distract from a hearing. And the rules are, the process will be slightly different today. However, in general, the Development Services Administrator or designee will present their arguments related to the record made before the UDC, demonstrating the presence of substantial evidence to support the Commission Board's hearing, and that will be allowed for 7 minutes. Then the appellant will have 7 minutes to present their case, after which each party will have 3 minutes to present their final arguments. If your camera is on when speaking, unless you're reading from a document, please look directly at the camera, not at your screen. After each side has presented their facts, we will close the meeting to public hearing. And we will have a discussion period with the board. Okay, so again, a lot of our script is not exactly in line because this is a significantly different format of meeting. However, the result of the meeting will be either a remand back to the Urban Design Commission, a reversal of their decision, or upholding their decision. At this time, please mute your microphones if online. Everybody should turn off the audible alarms on their electronic devices. And I request the board members to keep their microphones muted unless you are speaking. If you raise a digital hand on the screen to request a, well, we don't have digital screen today. And so that's it, Ms. Knight.
Very good. The case on our agenda today is an appeal from the Urban Design Commission, noted as BAC 24-003, located at 2812 Horn Street. The tenant is Mr. Gaddy's Pizza by Priority Signs and Graphics. The zoning is in the CBRG, Camp Bowie Ridgely Gateway District. The appeal is of the Urban Design Commission's decision to deny the applicant's request for a certificate of appropriateness for a waiver from the Camp Bowie Revitalization Code standards and guidelines for a second attached wall sign where only one attached wall sign per tenant is allowed.
Thank you. And at this point, I would like to call the Development Services Administrator to present their arguments. Please introduce yourself, and you have 7 minutes.
Sorry, just 1 minute. I just want to clarify that they'll give a brief overview, and then you will hear the arguments, the 7-minute argument from the appealing party, and then the 7 minutes from Development Services.
Thank you very much.
Good afternoon. Good afternoon, Commissioners. My name is Ana Alvarez. I'm a planner with the Preservation and Design section. I have a little over a year with the section and about 18 years with the city. To give you a brief overview of the case the case requests, the COA that was requested for UDC 23-115-2812 Horn Street was for a waiver from the Camp Bowie Revitalization Code standards and guidelines to allow 2 attached wall signs per tenant space where only 1 attached wall sign per tenant space was permitted. To give you an overview of the applicable standards and design guidelines, we look at section 9.1, sign standards. For attached signs, it states for all ground floor commercial uses, retail, office, and restaurant, 1 sign per tenant space area to be calculated at 1.5 square feet per linear foot of tenant space, facade along the public street, frontage with a maximum of 100 square foot per tenant. We also included the section 6.2 for Ridgely Gateway. The intent of this part of the code is the building form and development standards are intended to address development along Camp Bowie between Horn Street to Bryant Irvin Road. Development standards in this character zone are intended to take advantage of its location as the gateway to the Camp Bowie corridor west of I-30. Generally, this character zone accommodates development on triangular blocks and odd-shaped lots created by the intersection of the traditional city grid with Camp Bowie Boulevard that runs diagonally through the zone. The goal is to provide for feasible development options on these blocks with awkward and small parcels by allowing consolidation of driveways and some street or alley vacations to make development more feasible within this zone. In addition, it states the site shall be planned in such a manner as to facilitate a more urban block infill development pattern with respect to building paths, parking, driveways, and service areas. It was presented to the Urban Design Commission a case background, which included the following. The proposed sign package is for a commercial space located at the corner of Locke Avenue and Horn Street. The building faces into a surface parking lot and is oriented towards Locke Avenue with frontage on Horn Street. The front facade of the commercial space is approximately 44 feet. The side of the commercial space is approximately 42 feet. The proposed use was restaurant is allowed by right under the property's CBRG zoning. The building is currently undergoing, so at the time the building was currently undergoing remodel work for the restaurant use and for a second suite to occupy the remainder of the building, which would have frontage on Horn Street as well. It was noted and stated to the Urban Design Commission that on July 25th, 2023, a certificate of appropriateness was approved administratively for the addition of 2 attached illuminated wall signs under a previous case number noted as UDC 23091. This was included in the staff report to notify the UDC of the original issuance of a COA issued in error. It was also noted that on August 4th, 2023, the certificate of appropriateness was revised to approve only 1 attached illuminated wall sign to go on the Locke Avenue elevation, which is considered the front of the space having the public entrance. The other signage was being brought before the Urban Design Commission for this waiver. We included also a part of the staff report, more information, and then also regarding the stipulation in the standards for the Camp Bowie form-based code district. It again allows only 1 attached sign per tenant with a total square footage per tenant of up to 1.5 square feet per linear foot of tenant space facade along a public street frontage up to a maximum of 100 square feet. So the waiver that was being brought before the UDC was again mentioned. It was for the second sign. The details for both signs were provided to the UDC, and this was in regards to dimensions, location, distances above the sidewalk, and in relation to the building overall. And can I use the clicker? Or can I use this to? Okay. So the first sign was noted as being approximately 10.83 feet long by 6 feet tall, 65 square foot total, with text reading Mr. Gaddy's Pizza. The applicant had this sign above the sidewalk at 8.33 feet on the brick wall next to the awning, which is above the pedestrian entrance to the unit. Just to note, I don't know if you can see this. This would be along this side on Locke Avenue. The second sign, approximately 9 foot long by 5 feet tall, 45 square foot total, with the same text reading Mr. Gaddy's Pizza, was noted on the proposed location and above the sidewalk at 10.58 feet placed on the projecting roof wall, which spans more than 50% into the suite. So this was, sorry, where's the wrong- on this side, Warren Street. It was also mentioned to the Urban Design Commission that the overall signage exceeded the maximum square footage permitted to individual leasing spaces. That would be the 100 square foot for each tenant space. The location of the second sign was noted as inappropriate, as it was proposed on the side facade, and being there, it would not preserve the rhythm of sign placement and location along the block. I made comment to the Urban Design Commission that the second sign would be inconsistent with the intent of the CBRG subdistrict as the gateway to the Camp Bowie corridor or the Camp Bowie Revitalization Code, which aims to promote and provide a more functional and attractive community through the use of recognized principles of urban design and allow property owners flexibility in land use, while preserving a higher level of detail in building design and form. I then went through the figures provided in the staff report and awaited for questions from the commission. Just to show you, Figure 2 noted the front facade of the proposed Mr. Getty's tenant space, so this one, and then the second elevation denoting where the second sign in question here. And then Figure 4 shows the proposed suite floor plan showing the public entrance from Lock Avenue and the employee door on the side elevation with the portico from Horn Street, which is here. So this would be the Lock entrance, and this would be the Horn Street doorway. And this is the floor plan that was pulled from the change of use permit. To proceed with the decision from the Urban Design Commission, they made a motion for denial of the, sorry, let me restate that. So the motion was made that the request for a certificate of appropriateness for a waiver from the Camp Bowie Revitalization Code standards and guidelines to allow 2 attached wall signs per tenant space where only 1 attached wall sign per tenant space is permitted be denied. The motion was made by one of the commissioners, Commissioner Stamper, and seconded by Commissioner Harper, 10-0 vote, so unanimously. That concluded the portion of the staff report that was stated, but then the commissioners did have some time to speak regarding the case, and I left that open for question from them.
Thank you.
Okay, thank you.
So at this time, we call the applicant. And I understand we have online Mr. Chase Singleton.
Yes, ma'am. Good afternoon.
Chase, if you can please tell the board what reasons you have that the Urban Design Commission did not have enough information to make their case instead of restating the merits of the sign. And if you can give us your name and your personal name and your company name, please, sir.
Yes, ma'am. Chase Singleton with Priority Signs and Graphics. I guess to start, I'll kind of give a timeline of events. We've been working with the city of Fort Worth for over a decade now, so we're well aware of the procedures and actions that need to take place before installing any signage, the inspections that need to be had before, putting the signs up on any buildings or, properties. So following those standards, we submitted for a sign permit. I want to say this was back in June 30th of 2023. So about a month later, we were told that we needed to get a certificate of appropriateness for this sign, which we applied for. The certificate of appropriateness was approved. From there, our sign permit was issued. We then, spent tens of thousands of dollars to fabricate this sign, go out to the job site, install the sign that was issued. We got the permit inspection, got it finalized, approved. It was built to the city standards. The day after our installation, we then received an email saying that the sign was approved by mistake, that we needed to take it down immediately at our cost. And this is after our client has paid for the sign, paid us for our services. And we went down the correct channels to do everything, in our power to make sure that we weren't doing anything outside of the city's standards. The main reason they're wanting this sign, as you guys have all seen, their business faces 2 street frontages, Horn and Locke. They wanted visibility from both frontages, which is understandable. We thought that we had done everything, appropriate, as we've always done in the past. So, that's kind of where we're at right now. Did
Okay,
you all
yeah,
have any questions for me?
Mr. Singleton, that is a good summary of what has happened. Today, what we're trying to do is to understand what evidence was not available to the urban design, if any, the Urban Design Commission. So we're simply looking at whether or not the process was followed correctly. So do you have evidence or information that might show that there was a lack of evidence to support their decision?
We were aware of the first meeting. I think I'd registered online, same with this one, and just requested that if our case were to be brought up and that if there were any questions that we be reached out to. We never received any phone calls or anything, so we figured that it passed, and then found out that it was just unanimously denied. So I don't believe that there's any evidence that has been supplied, that you all would need to be rehashed. But no, ma'am. Yeah, as far as new evidence, I don't believe that there is any.
Okay, thank you. All right, so I guess it's time for the 3 minutes.
No, we have the staff from the Urban Design Commission
Right.
here to show what evidence was presented to the board.
Okay, and I apologize, this is not a typical kind of format, and as I understand, there's probably been one of these in the last 5 years, and I wasn't around, so let's move forward, and I will take all the direction that I can get from my colleagues and from staff.
Okay, so given the overview of events, I do want to let you all know that from the UDC perspective, what was presented to them in regards to the staff report was first the site plan or the site layout, and it shows, this is actually one that was provided by the sign company, showing the total amount of signs that were proposed for the site. The one in question is on this site, on Horn Street, and that's the one we've already stated was going before the Urban Design Commission for waiver. The Urban Design Commission discussed that there was quite a bit of signage already on site, so this is and it's noted here that the Urban Design Commission, I basically let them know that this is an existing pole sign and it was approved as a reface, so they already have this sign. And then also the one that was approved administratively here. With that, the Urban Design Commission made the decision that they already had enough signage based on what the standards and guidelines dictate. In the report that you all have, they discussed that it was already too much signage to allow them 3 signs. That's what was presented. Now, I guess I can make comment as far as the registration. They did not receive phone call. I believe that there are many ways to get registered, and then also email staff. There was a courtesy notice that was sent out on the 18th, and that stated the several ways that one could be communicated with. And then also during that day, I believe we do have the registration information that was submitted. They could have reached out via email or phone call.
Can you just, when you say submitted, can you say who submitted to who?
So
Just
the
so I can picture.
registration was made through WebEx, and the WebEx registration states who was registered for the meeting. Does that answer your question?
Was the applicant invited to the meeting?
Yes.
And we have proof of that.
So yes, we do. We have emails. The courtesy notice was sent to the case manager, and that was noted as Mike Prezizio, and then also included the sign company's, sorry, did I push something? Am I showing evidence or?
What we have on the screen is the actual WebEx registration from the applicant that shows that he registered about 8 a.m. the day of the UDC hearing. And, pardon me?
Registered mean.
It means that the applicant went into the WebEx invitation and asked to be part of this meeting, just like he did for today's meeting.
Also, the contacts that were noted on the case file included the general email for the sign company, and then at the time, the person that was noted as the case manager, which was Mike Prezizio. That's who was notified of the meeting. And then ahead of the meeting on Wednesday, I sent another email and let them know how they can register, and if they had any questions, they could reach out.
Do you have a copy of that,
A copy of the
the
email?
emails?
Yes.
Can someone explain what we're looking at right now? This,
Yes, I'm sorry, I had given the registration for today, but this is the actual UDC registration, virtual registration for the September meeting, where Chase Singleton is noted as registered at 7:57 a.m., but that he did not attend.
Staff, do we have to, are you finished with your presentation?
Yes, that was the rebut, just the proof that we had sent in the information to them, the registration information.
Okay, thank you very much. All right, and Mr. Singleton, you have 3 minutes to present your final arguments.
Yes, ma'am. No, I do not want to deny that I did not receive notice and emails and, all of that for the last meeting. Unless I'm mistaken, the last meeting, there was an option when I had registered to receive a phone call if there was any opposition, which we never received a phone call. And obviously there was opposition. So, without further divulging, I feel that we went through all the necessary channels and did everything appropriately. We received our approved issued permit. We built and installed the sign. And then we're told after the fact that we can't have the
Right.
sign. And that's after many hours of labor, many people were paid, materials were bought.
Yes, yes, we understand all that part. Okay, so there's nothing to add?
No, ma'am.
Nothing new to add? Okay. And staff, do you need another 3 minutes of final argument?
I think it might be helpful if y'all explain what actually being called to speak actually means for the public hearing.
Being called to speak for the public hearing is when you sign up and you get registered, you are in attendance in a meeting room in the WebEx. And then when it comes time for the case to be heard, you're allowed to speak when the commissioner allows you to speak. So when you're called upon, if the person is there, then they just unmute themselves. And at the time, the transcript showed that there was no one online. Does that explain?
So being called does not necessarily mean that we will give you a special call and try to round you up for the meeting to speak right then, is that you already need to be in attendance. Is that what being called to speak means? Is that you already need to be in attendance at the meeting?
I believe, yes, you need to be online or physically in the meeting or
Right.
however it's.
But in attendance, either virtually or in person, you already need to be in the meeting as opposed to waiting for us to call you and round you up.
I don't know that I can clearly state that. I don't know the process of WebEx, but I can say that that's what we were looking for.
Okay.
Okay, and Mr. Jones has a question for you as well.
Probably for staff. I'm looking at the timelines here, and on July 25th, the certificate of appropriateness was approved, and then on August 4th, it was revised. But what's on our screen now is showing a date of September 19th, which is after. So
Yes, so.
what happened in the three different?
The different dates. So initially, the certificate of appropriateness was approved on that date, noted in the staff report as administrative, as an administrative COA, in error. So then we were notified by the nonprofit organization Camboy of an error in the code standards, how it was interpreted. And so we spoke to the sign company, one of their technicians, their representatives, and let them know that based on that information and other information we found, that a waiver is possible for them to seek that approval for the second sign, but not through the administrative process. So those are the two dates you see.
So then did they come before, then Mr. Singleton signed up to, for the September meeting for the Urban Design Commission?
Once the application was submitted for the COA of the waiver, that was the soonest we could get him to the Urban Design Commission.
A second question. Had they, so if I understood him correctly, Mr. Singleton, based on them getting the approval, administrative approval, they then went ahead and put the signs up. They were notified on August 4th that was done by mistake, and then they came with a waiver in September, supposedly asking for a waiver to leave those signs up, correct?
That is what he's stating, yes.
And then no one was on WebEx or in person?
Correct.
Okay, thank you.
I do, sorry.
Just clarify a little further. Administratively approved mistakenly on the 25th of July. And then you said that when it was found out that it was a mistake, that your department contacted the sign company and told them that there was, a mistake. Had the signs been put up by then, when you called them?
So I'm not certain, but if you look at the transcript, it was noted by the nonprofit organization Camboy District, Inc., that the signs were already up 2 weeks prior to the certificate of appropriateness being issued.
Right.
So I don't know that I can answer that for you.
Yeah. Mr. Singleton said that it was denied a day after they put up the sign, and I didn't understand if it was the denial of that waiver request in that hearing, or was it the August 4th revision?
That would be a question.
So, okay. Mr. Singleton, can you just say the date that the signs were installed?
Yes, sir. So the signs were installed on August the 3rd.
And
And then we received the notice August 4th.
was that the first notice or call of any sort that you received from the city that your administratively approved sign had been denied or was a mistake?
Yes, yes, sir.
I have a question for Mr. Singleton. In general, how long does it take to manufacture those signs?
Typically, we're looking at around,
Hang on just a second. Hang on just a second.
process.
Yeah, that's,
Christopher Austria, representing city staff. I don't since that information was not provided at the time of the hearing itself, I don't believe it should be considered as part of this appeal itself because it wasn't part of the record.
Withdrawn.
thank you.
Mr. Austria, could I ask, do you think what I brought up with the timing, I read in the transcript about July 25th and August 4th. Can you
I
say?
would not be the appropriate attorney to answer that question, only given the fact that Mr. Arias is representing the board and I'm representing UDC staff itself.
Okay.
So with regards to
I'm
the
just
question
wondering.
itself, I'm basically objecting on behalf of the UDC. But I
Okay.
will let,
Procedurally, I'm asking.
Yeah, so I would take a look at what's in the record, what has been presented to you from staff. If it wasn't in the record, I would advise you not to consider it. Now, however, it is up to the board, to you all, to decide whether or not that would be considered new evidence.
I'll just say that the only reason I asked was because in the transcript it says signs were erected prior to application, and I wasn't sure what that date was or when the signs were erected. It sounded like somebody at the hearing knew the date that it was erected, and it had been erected by the time of that hearing. But that's why I'm just clarifying.
Yes, yeah, I understand. So I would I would advise try not to ask questions to get that further detail, but then it is then your all judgment as to whether or not that would constitute new evidence.
Do we have any other comments or questions from the commission?
I do want to let you know also that the date that was just given as August 3rd was the same date that I sent an email to the representative of the sign company, noted as Angie, to let her know of the, what was brought to our attention, the misinterpretation, incorrect approval. Yes,
Can you
sorry.
provide proof that you sent that email?
Yes, I
please?
have the emails here. It's an email thread, and I can show it on the below. But what I wanted to just reiterate louder is that on August 3rd, I sent the email to the representative of the sign company, noted as Angie, and let her know that it had come to my attention that it was approved in error. The
Was
initial certificate.
that presented before the Urban Design Commission?
No, what was presented before the Urban Design Commission was what was on the staff report. The
Okay,
notes.
then that's new evidence, right?
It's,
if the board determines that to be new evidence, then it would be up to the board to determine whether or not that is new evidence. If you believe that is new evidence,
I mean, none of the records I've received in the transcript or anything of that nature cites an email chain or anything of permit, when it was issued, when it was inspected, when they were notified.
So that,
So to me, that we're here to understand if they received a proper hearing based upon this evidence. And going to that extent, I would say that we're asking for new evidence.
the question arose because she brought it up. She stated that they made phone calls. You stated that you sent out emails. He stated he didn't. So therefore, being that the representative have stated, that's the reason why the request is made. So if new evidence is brought in, it's been brought in by the representative.
and if that is the case, then there is one motion that needs to be made if there is determined to be new evidence presented before the board and the UDC would need to reconsider the hearing given that new evidence. So I just want to make sure that the board understands, if they were to determine that to be new evidence, then the motion should reflect the fact that there's new evidence that has been presented before the board.
Thank you.
Thank you.
Any other comments or questions from the commission?
I'll just make a comment just because I'm comment-like, but, so I think I know which direction we're going, and it seems like the appropriate thing to do. However, I feel like in the appropriate use of city staff time.
I would not recommend making
I know
any
we can't do
judgments.
that. I'm just saying, if we're writing letters to our city council members, there needs to be a new process for permits that are issued and then revoked.
I don't think this is the appropriate time period for such comments on the record itself.
I know. I just apologize to all the staff members who are going to have to deal with this. But
Thank you.
Yeah, I think this might be a good time to close the public hearing and see if we have any other comments or a motion.
Well, I have a comment. Concerning timeline, if the Camp Bowie District brought it to the attention of the city that the signs were up before the July whatever, I think we kind of required to send this back to urban design.
I have something too. When we're focused on the process, we have a couple glitches that I believe may have occurred, and I think I'm going to come to the same conclusion as Mr. Jones, because we can see how it is possible for someone who may not have experience with online meetings and some of the terminology we use on a regular basis when it comes to being called upon or called, because the screen didn't show you're going to be called upon, it said you're going to be called. So I can see where that misunderstanding might happen. When you have a party that's making a claim that a sign was installed at a certain time, and then the applicant could have refuted that with their actual facts that they could have presented at that time, that was an unfortunate result of not knowing to be online, to be called upon. So there was a lack of total process and knowledge on the applicant's part to fulfill their obligation for their role in the hearing. So to that end, unless we have another discussion, I could make a motion.
Thank you, Mr. Perez. Does anybody else have any comments? Okay, we're open for a motion.
Okay, I'd like to make a motion that on, case number. Let me pull this up very quickly.
BAC 24-003.
Thank you. As stated, this case number, that my motion be to vote to remand this case back to the Urban Design Commission for further review in light of this new evidence involving procedure.
Second.
Thank you. So Beth, Ms. Knight, if you would conduct a roll call, please.
Yes, on the motion to remand this case back to the UDC due to the new evidence being presented, your vote, please, Mr. Lindsay.
Yes.
Thank you. Ms. Holland, your vote, please, ma'am.
yes.
Thank you. Mr. Perez, your vote, please, sir.
Yes.
Thank you. Mr. Jones, your vote, please, sir.
Yes.
Thank you. Mr. Riley, your vote, please, sir.
Approve.
Thank you. Mr. Wilson, your vote, please, sir.
Approve.
Thank you. Ms. Duffy, your vote, please, ma'am.
Yes.
Thank you. Ms. Powell, your vote, please, ma'am.
Yes.
Thank you. Ms. Herrera, your vote, please, ma'am.
Yes.
Thank you. And Ms. Dottie Munoz, your vote, please, ma'am.
Yes.
Thank you. That motion passes unanimously, 11-0.
And Ms. Freed also agrees yes.
Thank you. I appreciate you, since I skipped that.
Okay, so that means that you will once again go through this process. And you have two choices in participation. You can either come in person or do it remotely. And probably the path of least confusion might be to be here in person for the next hearing, or someone from Mr. Gaddy's, or from your company, but that's just it's not necessary. It's just would probably be helpful to avoid confusion. So if that being the case, and this is the only case that we have today, I believe we are now adjourned.
Yes, so Mr. Singleton, please, at the next meeting, if you decide to attend virtually, be in attendance at the meeting, either virtually or in person, and then you will be called to speak. You will not be getting a separate phone call from staff asking you to show up at the meeting.
Yes, ma'am. Thank you.